You know, when an AI makes a huge decision about someone's life, have you ever wondered what's actually happening inside its brain? Well, the European Union decided we absolutely need to find out. They've basically created a flight recorder for artificial intelligence, and it's all packed into one critical piece of law, Article 19 of the EU AI Act. Let's unpack it.
Okay, imagine this scenario. A company uses a high-risk AI to screen job applications. You spend hours on your application, you send it in, and you get rejected. But why? Was it your experience, your education, or was it something totally hidden deep inside the algorithm? This is what we call the black box problem. When AI is making these massive decisions about our lives, we often have no way of knowing how it got to its answer.
And that is exactly why we need a flight recorder. I mean, think about it. An airplane's black box records everything that happens on a flight, so that if something goes wrong, we can figure out why. The EU decided that high-risk AI systems need the very same thing, a way to record their own operations. This creates a digital trail we can follow to understand what happened, check for fairness, and most importantly, hold these systems accountable.
So here's how we're going to trace the story of this idea. We'll start with the problem itself. Then look at the first kind of vague proposal. From there, we'll dive into the legislative tug-of-war that really shaped it, see how the final rule was hammered out, and then finally, we'll talk about why these logs are just so incredibly important.
All right, so let's start with AI's black box problem. When AI is used in these really high-stakes situations, we're talking hiring, credit scoring, even law enforcement, its internal logic can be unbelievably complex, totally hidden from view. And this lack of transparency makes it almost impossible to check for things like bias, errors, or discrimination. It creates this massive, glaring need for accountability.
So, what was the EU's answer to this puzzle? Well, it's something called automatically generated logs. Now, at its core, the idea is really simple. These are just records, generated by the system itself, that create a digital trail of the AI's actions. A pretty straightforward concept, right? But this simple idea became the entire foundation of Article 19.
But it definitely didn't start out so clear-cut. Let's rewind back to the beginning, the European Commission's very first proposal back in 2021. This was the first real attempt to create a rule for AI record-keeping. And look, it was a decent starting point, for sure, but as we're about to see, it was just full of holes.
And you can see the issues laid out pretty clearly here. The initial proposal said logs were required, which, hey, great start. But the weaknesses were huge. The retention period was just appropriate. What does that even mean? A week? A year? And a provider's responsibility was limited to logs they controlled through a contract. This created this giant loophole where a provider could just sidestep accountability by, well, not having a specific contract in place.
So, these weaknesses, they set the stage for a classic legislative tug-of-war. This is a dynamic you see all the time in EU policymaking. On one side, you've got the European Parliament, and they were pushing for much stronger, much clearer rules. And on the other side, you have the Council of the EU, which represents the member states. And they were often leaning towards a more limited, you could say business-friendly approach. The battle between them would end up shaping the future of AI accountability.
And this back and forth played out for over 2 years. In June 2022, folks in Parliament proposed a concrete 6-month minimum for keeping logs. The Council actually agreed to that time frame in November, but they held firm on their narrow definition of provider control. So Parliament pushes back again in mid-2023, demanding broader responsibility. But by late 2023, the Council had really dug in its heels, which set the stage for a final showdown.
And this right here, this gets to the absolute heart of the conflict. The Parliament wanted a simple, broad rule. If you control the AI system, you're on the hook for its logs. Simple. The Council, though, wanted to add that little phrase, by virtue of a contractual arrangement or otherwise by law. It seems like such a tiny detail, right? But it would have created a massive escape hatch for providers to avoid responsibility.
So how did they finally solve it? Well, after some really intense negotiations, they reached a final compromise text in early 2024. This final rule managed to blend the positions of both sides to create a regulation that was way stronger and much more balanced.
And this comparison just shows how much the rule evolved for the better. I mean, look at this. The final regulation sided with the Parliament's broader definition of provider responsibility. It cemented that 6-month minimum retention period. And, this is a big one, it explicitly linked the rule to data protection laws like GDPR. That's the General Data Protection Regulation. The first draft totally ignored that. This was a huge win for transparency.
So let's just recap the key features of the final, much stronger version of Article 19.
Provider responsibility is now broad, the retention period is clear and concrete, data protection is baked right in, and it even includes some practical rules for specific sectors, like finance, so it doesn't create a bunch of unnecessary paperwork.
So, after all that legislative drama, why does any of this matter in the real world? What's the actual payoff of having this rule? Well, it all comes down to two things: accountability and trust.
These logs really serve three critical functions. First, they enable traceability. This lets us reconstruct an AI's decision process if something goes wrong. Second, they facilitate audits, giving authorities the hard evidence they need to check for compliance. And third, they help providers themselves monitor their own systems out in the real world, hopefully catching risks before they can cause any harm.
And at the heart of all this new accountability is one concrete number: 6 months. That is the minimum period these logs have to be kept. It really represents the shift from a vague idea of appropriate to a specific, enforceable rule that providers have to follow. It's a simple number, but it represents years of debate and a major step forward for AI governance.
So we've done it. We've successfully built the flight recorder for AI. We know what it records and for how long. But of course, this victory immediately raises the next big question in AI governance. Now that we have all this data, who actually gets to see it? And under what circumstances? Well, that's the next challenge we're all going to have to solve.